All right, if I can have your attention, thank you for coming this evening. I do expect that we're going to have some others coming in as we're beginning this presentation on the legal aspects of why we do what we do, who does what. It's been 4 years since I've been here. I'm starting my 5th year. In looking at the different activities that occurred in Ohio, it was very readily apparent that it's not an easy line to figure out who's supposed to do what. We've worked through a lot of different regulations over the years. We've worked through the ORC, we've looked through what our attorney says, we've looked at items. Part of what you've heard from me and our office is that we have to make sure that we have the authority to do what we're doing and know who has what authority. So based off of that, we put together what will be a new orientation for new members, as well as a refresher for those who've been here for years. We are videotaping this so that we'll be able to put that online as we put other things. So it will be a training resource available to Planning Commission members as well as those who are in townships. So with that, I'm going to turn it over to Brad Mercer. He's going to introduce our guest, but I do want to say this very quickly. Don, I appreciate you coming out. Peter, thank you. I've heard Don several years at conferences, and he makes law actually interesting and fun to us. So, Brad?
Tonight we have 2 guest speakers with us, and they're from, there's Mr. Brosius here, Don Brosius, and Peter Griggs. They're with the law firm.
Or should we wait?
I'd wait. Boo!
They graciously offered to, we contacted them and asked if they would be willing to speak, and they graciously offered to come and help us do a presentation here tonight. So I thank you guys for coming and working with us to set this up. As Jerry noted, we're going to talk about the regulatory authorities of this body, and then Mr. Brosius and Mr. Griggs are going to jump in and kind of speak on the law a little bit about that, and how it should be applied to us. The Planning Commission, the body itself, is established by the Board of Commissioners, and the Board of Commissioners appoints the members of the board. 3 members of the board are the Board of Commissioners, as you're aware, and then the other 8 members are appointed by the Board of Commissioners. And of course, each of us, or each of the board members, has an alternate that they identify and submit to the Board of Commissioners. So basically, the body is 11 member board. Members are appointed for a term of 3 years, and members can be allowed expenses. I know there for a long time, the joke at the end of the year was they're going to give themselves a raise of 0 because you all volunteer and help us perform this function. So, and for that, thank you. And members of the Planning Commission may hold other public offices and may serve as member of a city, village, or regional planning commission, except as otherwise provided in those city charters. So many of you are serving as board members. You also are board of trustees. And I know some of you also serve on other boards and committees in the county. So that is provided for in the Ohio Revised Code. The Planning Commission Board may employ engineers, accountants, consultants, and employees as necessary, make purchases in order to fulfill their operation, and accept and receive and expend grant services from federal and state and government agencies. With that, you're also allowed to coordinate with those agencies and fulfilling their functions and to implement those grants. The Planning Commission may also prepare plans, including studies, maps, and recommendations, promote understanding and recommendation of administrative and regulatory measures to implement those plans within the region, and collect, process, and analyze economic data. We also may contract and provide planning assistance to other local government agencies. Right now, we administer the floodplain regulations for some of the villages within the county. For example, Village of Alexandria and Hartford have, they're small villages. They don't have a full-time staff, so they've contracted with us to help administer their floodplain regulations. We also, like I said, may cooperate with state and federal government agencies and planning activities and programs. We may review and evaluate, make comments and recommendations on proposed amendments to conference plans, open space, transportation, and public facility plans, and projects implementing measures of local government. Throughout the years, this body has worked with townships and reviewed and made recommendations on their local plans. Once a township adopts those plans within the county or within their township, they submit them to us for review, and then this body adopts it as part of their planning process. And then we transmit those to the Board of County Commissioners, who adopt them as well. We also may review, evaluate, and make comments and recommendations on public facility projects within the region, and conduct experimental and demonstration projects found necessary in the development of plans in the county. So that's kind of a general overview of the authorities and powers that the Planning Commission has. Next, we're going to go into actual regulations that this body administers. Currently, the Licking County Planning Commission administers the subdivision, land division, development, and congestion prevention regulations for Licking County. We administer the Licking County access management regulations, which apply to all the township and county roads within the county. They do not apply to state roads. We administer the flood damage prevention regulations for the unincorporated areas of the county. And we also administer, I didn't put it on here because this body doesn't really address it, but we administer the North Heath Airport Airspace Zoning Resolution. That's mainly handled at the staff level because there's a separate board appointed by the Board of Commissioners that hears appeals and variances. So staff basically administers and issues permits and the like. So basically the main three regulations that we are administering as the Planning Commission board and staff are these three up here. In regards to the subdivision, land division, development, and congestion prevention regulations for Licking County, they contain the subdivision regulations, public improvement regulations, and erosion and sediment control. We're going to focus on those three here shortly. We also, access management has authority through Chapter 5552 of the ORC, and flood damage prevention regulations for Licking County are authorized by Section 307.37 of the Ohio Revised Code. I'm not going to spend too much time on these, as we've talked about access management previously when we were going through our series of amendments a couple years ago. And then flood damage prevention regulations, that alone can take a whole training session, which we may do in the future. So like I said, we're going to focus on these three here. With that, each authority is provided by the Ohio Revised Code, and then that authority is authorized to a certain body or board. that body or board has the ability to delegate that authority in some instances. With the subdivision and plating, that authority comes from 71110 of the Ohio Revised Code, and that is the Planning Commission Board authority. Public improvements are authorized by 711-101 of the Ohio Revised Code, and that's the Board of Commissioners authority. And with that, the Board of Commissioners have delegated that authority to the Planning Commission for administrative purposes. So basically, the board and the staff administer those regulations on behalf of the Board of Commissioners. But to adopt any of the regulations, that's the Board of Commissioners authority. Erosion and sediment control is section 307.79 of the Ohio Revised Code, and that's the Board of Commissioners authority. And again, they've delegated the administrative aspect of that to the Planning Commission for reviews and appeals and variances. Kind of put sediment erosion control in perspective, when we talk about Article 6, when we're doing preliminary plan and final plat reviews, that's the body of regulations that mostly applies to. Access management is the Board of Commissioners authority, authorized again by 5552 of the Ohio Revised Code. And again, that's delegated for administrative purposes to this board. And then floodplain management, again, is a Board of Commissioners authority that is delegated for administrative purposes. So of the regulations that we administer, the subdivision and plating is the sole authority of the Planning Commission. The other regulations, its authority to adopt regulations lies with the Board of Commissioners, and the administrative authority has been delegated to the Planning Commission staff and board. I'm going to start with public improvements and then kind of delve into these each individually. As I said, public improvements is the Commissioner's authority. Public improvements can regulate streets, curbs, gutters, sidewalks, street lights, water mains, storm sewers, sanitary sewers, and other utility mains and piping. We can also implement rules for bonding and securing the construction of those improvements. And the rules are strictly linked to improvements shown as they are shown on the plat. So basically, if the plans and the plat comply with the regulations, then we have to approve them. So basically, we have authority to administer and regulate those items listed, which again were streets, curbs, gutters, sidewalks, streetlights, water mains, storm sewers, and sanitary. And we develop regulations on how those are to be constructed. If they comply with all those regulations, then there's no reason to deny a plan or plat. So the only time you guys, as a board, Planning Commission board, would see these if they don't comply with those construction requirements of the regulation and they're seeking a variance. The Planning Commission staff administers these with the Planning Commission board. The staff reviews the plans that are submitted to the Planning Commission through applications that are provided to the developer. So the developer would fill out an application form, and that basically starts the process when they submit that to the Planning Commission staff. The other agencies that are involved of public improvements is the County Engineer's Office, who acts in an advisory capacity, and the County Soil and Water Conservation District, but also, in some instances, if it's related to drainage, provides an advisory capacity. On this chart, it shows each agency's authority and how that's addressed across the board. So for public improvement, again, it shows the authority, Planning Commission, the advisory capacity of the town, or the county engineer. The county prosecutor may be involved if there's a legal issue. And then the township, once the public improvement is constructed and the plat's recorded, then they receive the infrastructure for public maintenance. So with a platted roadway, once the road's constructed, been inspected and accepted for, that it complies with the construction plans, then it's turned over to the township for public maintenance. So that's a brief overview of the authority and how that is administered throughout the county. Do you guys have any additional comments?
I'm always willing to talk, even when I'm not being paid. First of all, thanks for having me. I mean, it's, my name's Don Brosius. My partner's Pete Griggs. I'm an attorney in Columbus with the firm of Brosius, Johnson & Griggs. And 100% of my time is spent representing local public bodies. That's all I do. Primarily townships, all around the state. I also I've represented regional planning commissions. We represented Delaware County for 20-some years. I've done special counsel work in municipalities. I refuse to represent a municipality on annexation. I won't do it. Nor will I represent any developer on a rezoning or zoning matters. I've been asked, but I won't do that. And it's fun. I enjoy it. You know, I was asked here to talk about the law, you know, and I'm thinking to myself, every one of you on the planning commission, you really don't have any special expertise. You were appointed probably for a variety of reasons. Could have been location, could have been your background, It could have been because you knew a commissioner. I don't know. But at the end of the day, they drop you in the seat, probably give you a copy of the sub-regs, and say meetings are this date, have a good time. They don't tell you the bad stuff. The bad stuff is, I hate subdivision regulations. They are as clear as mud from a legal perspective. Trust me. I would much rather deal with the zoning questions. Sometimes when I deal with subdivision issues, it reminds me of W.C. Fields on his deathbed. Somebody said, and he's reading the Bible, somebody says, what are you doing? He says, looking for loopholes. That's subdivision regulations. But, you know, all you're trying to do is your best. And the thing to remember, I think, is two big things. Number one, trust your staff. Unlike zoning, when I'm dealing with zoning cases in townships, or a municipality, done that, when they're dealing with a rezoning, they're making policy. They're hearing arguments about why something should be this way, why it should be that way. And that's both the zoning commission and trustees. And when you're making a recommendation on a zoning, you're recommending based upon policy. Not true with subdivision regulations. You don't make policy. You have only that authority that's in those regulations. You might say to yourself, well, we think it ought to be this way, or that way, or whatever way. It doesn't matter. It doesn't matter what you think. It's what it says. And sometimes that's frustrating. I mean, I'll give you an example. Last week I was dealing with a township in a different county. One of the trustees, pretty upset. Neighbors have been residents have been calling him and saying, hey, this guy's bringing his semi-truck home, parking it there, leaving in the morning. So he calls me and said he wants me to talk to the zoning officer. And says, we need to cite him. He's running a business out of his home. I said, how do you know? You know, well, he has a truck there. Maybe it's the vehicle he uses. That's all. And that's what he really was doing. He was driving it to and from the house to his business, or the business down wherever he was, and coming back. And I said, you don't have it's not an unlawful business being run. Your problem is it's a parking issue and you don't have a regulation that deals with it. And the answer is amend the code. He didn't like that answer, but that's the answer. When you're dealing with subdivision plats that come along and you see something, that you might want to think about, oh man, I wish the subdivision regulation said that. The answer is change the code, assuming you have the authority. And don't forget, any amendment you make to a subdivision regs have to be approved by the commissioners. But in any case, when you look at, when Brad went through the various statutes, I mean, if I were sitting in your seats there and I'd think, I don't want to know a bunch of law, because you're not going to walk out of here remembering it's this statute or that statute or whatever statute. You're not going to remember that. Remember, when you're sitting up there, you're not really making policy. Your job is to administer a set of regulations that are already in place. That's your job. And secondly, my experience in platting authorities is that much of the work is done at the staff level. My suspicion is you rarely see attorneys at your meetings. You see engineers, you see surveyors, you see property owners, but you don't see an attorney. It's rare, I think, when an attorney comes. And why is that? Because it's really an administrative sort of a process that's done, a lot of it at the staff level. Your tech review committee. They're trying to ferret out the problems based upon the property that was zoned comes to them. Now we got to plat it. Zoning deals with land use. The use of the property, if you want to complain about that, you can't. You don't control the use. You control the way land is divided. That's your authority, the way it's divided. And the purpose of subdivision regulations, really, when you look at the statute, is to coordinate the streets and the utilities. That's the real purpose of subdivision regs. It's the coordination of streets and utilities. So you don't have a hodgepodge of road going here and stopping, road going there and stuff. That's what it is. But when you're looking at a plat that's coming to you for preliminary approval, your staff has probably already educated you as to where it is. Does it comply with the subregs? Are we looking at a conditional approval? Are we, it's been through that process. And you've got a good staff. And that's who I'm going to rely on in most of the instances. And when it comes to the final plat, this county does not permit you to bond off improvements. I'll tell you what I mean is this. Some counties, if I wanted to plat 100 acres and I wanted to sell lots like right now, hurry up and sell lots, I can't do that until the improvements are completed and accepted in Lincoln County. But if I were in another county, what they let me do is they actually let me post a bond for those improvements. And I get my plat approved. Now, I'm not a big fan of that because it creates problems. Brad and I were talking up there about the bond issue. I would not recommend the commissioners allow for that. That's their prerogative. And the reason is, if you have a recession like we just went through, there's a lot of people going belly up. And there's a lot of bonds that they're going to have to yank. And that's a lot of responsibility. I would not want to be in the revoking bonds and building business. I like the way you do it. I think it makes a lot of sense. But really, it's a matter of, in my mind at least, relying on your staff and knowing what your authority is. And your authority is really in subdivision regs. Everything else, the access management, now it's unusual, I believe, for a planning commission to be administering access management regulations. Normally, the county engineer has taken that authority. Evidently here, The statute says the county engineer has first shot. That's what the statute says. Then it goes on to say that if he refuses or doesn't want to do it, then the county commissioners can delegate that to some. So evidently the county engineer says, I don't want to do it, which surprised the heck out of me. Because most county engineers do perform that function. But be that as it may. Again, that is typically a staff-driven review. And so, you know, and when you're here, we're talking about legal authority, ask questions. You know, if you have a question to me about whatever, I always like interactive things. You know, I don't like you sit there and you're thinking, God, this is boring. What time's our meeting? Jeez. You know, have fun. I mean, yeah, it's a great way to have fun. But ask a question. I mean, I don't know. I don't have all the answers. I wish I did. I do a lot of this work, but you never know it all. You never know it all. There's some things in your subdivision regulations that I'm sure I can have a philosophical discussion with you guys and basically say, what authority do you have to regulate this? And I know what you would say, and then I would come back, give you a comment. Do you have the authority to regulate a condominium? Treating it as a development and not a... I think there's an argument you do not, but it's in there. There's a statute, 5711, the condo statute. I think it's 5711. Getting old. It is 5711. The condo statute says a condominium is not subject to 711, the planning regulations. But I've noticed we bring it in under a development review process in some instances if I'm right. Make sure I'm reading that right, that I'm not saying...
No, actually you are, and this is pointing to items that we'll hear later tonight.
Oh, really?
We've been looking to take our regulations and show what authority we have and get them into the proper, because as Don has just indicated, and what we've been telling Planning Commission is sometimes I think we're regulating things we don't have the authority on. He's pointing to one. So what we're working on is making sure that we have the proper authority on everything we're working toward doing.
It's perfect. I mean, that's what you want to do. And really, you have good staff. And I would take advantage of that. I mean, you're never going to be the expert in this. It's not going to happen. And you don't want to be. You know, it's bad enough you've got to take up an evening once a month. It's also bad enough, what you don't know is you're also now a, quote, public official. That's not a fun thing to be. You are now subject to the Ohio ethics laws. You're thinking, what's that mean? If you're ever dealing with a plat of obviously, you cannot participate in a development of your own, or your family member, or your business associate. You can't participate. And participation is more than voting. You can't participate in discussion or vote. Where the rub is, and where the gray area is if you have a piece of property that's being developed near you, near where you are, where you live, or where your family member lives, or a business associate has property. You have to say to yourself, do I have an obligation to abstain from discussion and vote? And the question is, will that action result in a benefit or detriment to that property that you have? That's the question. Even if you would say, well, it's going to hurt my property because it's an industrial development. Doesn't matter. Got to abstain. So what I would do is when you smell something coming down the pipe, I would probably call Jerry or Brad or Chris and say, hey, I noticed this was on the agenda. Could you check and see if I'm okay on this? And it's that little bit of awareness. On the Ohio ethics law, everybody knows. You're not going to take money for a vote, or that's easy stuff. or you're not gonna go out, somebody gonna spring for some fancy dinner, that's really easy. It's this other stuff that's not so intuitive. So with that, I probably got one I should.
Just a question,
Yes.
all of that though, how broad is that? You live in a small community, and any positive development in that small community, the rising level of water raises all the boats. Most of the people in here are property owners, or have an investment in this community, the county. So most things that we do are either positive or minus.
If
See
it's
what I
ne-
mean?
If it's next door to you, if it's adjacent,
That's
easy
touch.
answer.
Yeah.
If it touches. If you're across the street, easy answer. You can't do it. Where it becomes a little bit more gray is there's an ethics opinion out there that says if it's nearby, I'm serious, that's what it says, nearby, you have to abstain. And that, was it 150 feet?
150 feet.
150 feet's nearby, so.
Yeah,
We don't know about 151.
160 is good.
Yeah,
right?
yeah, I don't, yeah, we don't know.
It just said 150 feet. There's an issue there and you can't participate.
Yeah,
But it didn't go any further than that. We don't know if it's 160
Yeah.
or 200.
but occasionally that does happen for people.
Oh, it does happen.
Yeah.
It's, yes, ma'am.
I have one tonight.
Shut the camera off.
What was 16-minute gap in the tape?
And that's my question. It's on erosion and sediment control. We're upstream. I mean, no matter how big a muck hole they make next door, it's not going to wash onto us. But am I allowed to recuse myself and come out here and sit?
Are you
for-
next door?
Yeah.
Oh, I would probably abstain. If I'm next door, that's an easy answer. I'm probably going to abstain.
I think her follow-up, though, is abstaining one thing, but then can she be the citizen and participate in the conversation?
That was my question.
Can you leave the table, abstain from discussion and vote, and then come out here and what? Complain about it?
No, not complain about it, but ask questions to make sure, as I said, they can make as big a muck hole as they want and it's not going to wash onto me.
Yeah.
But I want us to make sure that it's done correctly.
What you can't do is this. You can't come out here in favor of it, and you can't come out here and represent some of your neighbors and say, I'm for it or against it.
Right.
You can come out here and represent your own interests and ask questions, but you can't do anything to influence any vote.
Okay.
Yeah. Yeah, what happens is sometimes I get these questions from board members, and what I've done, the Ethics Commission has a hotline. You can call down to their office and you can get a staff attorney. And you can run the question up the flagpole. And they'll give you what I call a drive-by appraisal. You know? And it doesn't protect you. If somebody would file an ethics complaint and it's determined to be a violation, that drive-by doesn't protect you. What protects you, the only protection is a formal opinion from the Ethics Commission. The problem is it takes 3 months,
4 months.
3 or 4 months.
Yeah.
Basically.
So if you're out here, something like Rhonda was saying, you can ask questions, can you also offer opinions?
Yeah, you can say I'm opposed to it.
Or because of these reasons, I'm opposed to it?
Yeah,
Okay.
you can do that.
So you can also state your opinion about it?
Right,
As a citizen.
as a citizen,
Okay, okay.
as a citizen. But like I said, when you abstain from something, it's more than not voting. You can't discuss it, you can't, you know. And also remember, and I was talking to Brad upstairs, you are also a, quote, public body. You are an 11-member public body. So that if 6 of you would get together to talk about something, it's a problem, such a problem.
Are abstain and recuse synonymous?
Recuse yourself from discussion, and
Just
you're
step
abstaining
aside.
from vote.
I'll abstain from the vote. Are you obligated as a public official, if you're on that panel, and you say, I'm going to abstain from the vote, are you obligated to say for the record the nature of the abstention?
Not really, but no, there's no obligation to do that.
I've heard that that was required,
No, I think you should.
just as a matter of record.
Yes. Yes.
Or it's sort of like you walk away and everybody kind of wonders if they don't see the obvious connection.
Exactly.
Well, what are we, what are we not understanding?
You're in the public eye.
Right, you're a public official.
You really should say why. Well, I live next door. Or I live a house away.
For 149 feet.
Or 149 feet.
Yeah.
And that's what I would say.
Okay.
And people respect that. And like I said, if you violate that, it's not because it's intentional 99% of the time, it's because you didn't know. And it just, but these are the things they don't tell you. when someone calls you up on the phone and says, hey, we got a planning commission in Lincoln County. Do you think you might want to serve on it? Would you be one here? Sure. So, I mean, but as we go through this, please ask questions. Make it fun. And I got a couple more jokes too. Let people off.
So we covered public improvements and general overview of the function of this body. I'm going to kind of briefly go through the other two requirements and then turn it back over to Don, because I think you get more from him, his insight, than me just reading what the code is. But I think it's important that you know what the code says. So, with the subdivision and plating rules, again, that was authority of the Planning Commission Board. Those rules allow for the proper arrangement of streets in relation to existing and planned streets within the community. The rules can cover plats in regards to proper arrangement of streets, adequate and convenient open spaces for traffic, utilities, access to the public roadways, and for firefighting apparatus, recreation, light and air, and avoidance of congestion of population. The rules can require compliance with township zoning, which we do, and require that they have approval for on-site, with the health department regulations for on-site well and septic, or with, in the case of like Etna and Harrison, where they have a public water and wastewater with Southwest Licking, whether they comply with their requirements. We can, with the subdivision and plating, we can require a preliminary plan and a final plat. We do recommend a sketch plan, but that's not required. That's offered to the developer, and if they so choose to do that, that's up to them, but it's not a requirement. The benefits of the sketch plan is it allows to identify issues early on before they go through all the engineering, as we'll see later tonight. But it doesn't have a requirement in the Ohio Revised Code. So the only two plans that were authorized to require are preliminary plan and final plat. So this body reviews those two plans, and they go before technical review, which is kind of what Don was alluding to earlier, where the Planning Commission staff deals with all the issues pretty much before you see them. So those technical review committee meetings is where those are held. In Licking County, for those of you who are not aware, the technical review consists of our office, county engineer's office, soil and water conservation district, the health department if it's on-site and septic and well, or one or the other. The Public Water and Wastewater Authority, which would be Southwest Licking Community Water and Sewer District if it's in Etna or Harrison, or if it's down by Buckeye Lake, it would be Licking County Water and Wastewater. We also invite the township, which usually is the township zoning inspector and road superintendent, but the board of trustees members may come. And we also invite the fire district, and in the case of residential development, we invite the school districts. And then the remainder of the committee is made up of the developer and their representatives and engineer. So all those bodies are reviewing this at once to ensure that it's compliant with their regulations. We also, in instances where it abuts a state route, invite ODOT. And occasionally, we've invited Ohio EPA. For example, recently we had a development that's commercial and it exceeds the health department standards that they review, because they only review projects up to a certain amount of gallons per minute that is used. So anything above that goes to Ohio EPA. And so in those instances, we have invited the EPA, but those two agencies are, on occasion, they're not a normal member of the TRC. So anyhow, the technical review committee, we review all the plans that come before this body to ensure compliance with the regulations. And any recommendations that the staff is making is usually based off of those technical review committee meetings. So if we're recommending a conditional approval, that's based on output from that technical review committee. The next set of regulations is sediment and erosion control, and those are also embodied in our subdivision regulations. Again, that's Board of Commissioners authority that's delegated to this body, and the rules are intended to abate wind and water erosion of soil, abate the degradation of water, implement the area waste treatment management plan, which is normally called a 208 plan, which is adopted by the public body. We also can implement the phase 2 of the stormwater program, which is the National Pollution Discharge Elimination System, NPDS. You'll often hear that during our planning meetings. So basically, those regulations can have rules and standards to implement any of those regulatory authorized requirements. With the sediment and erosion control, those are administered by us. We do receive advisory capacity from Soil and Water Conservation District for the erosion control, and then the county engineer's office usually reviews the stormwater calculations and the pipe sizings and stuff like that. The other two bodies of regulations are access management. Again, that's Commissioner authority. And we can have rules to regulate the management of access onto county and township roads for the purposes of promoting traffic safety, efficiency, proper traffic capacity, and traffic flow. The other body of regulations, I already talked about sediment erosion control. So those are the main regulations that this body administers, and what we can administer within those regulations. Again, these charts are in your handouts that specify the authority. These two charts identify each agency's role, which are also included within the handouts. With the floodplain authority, for example, to briefly, because we didn't really go into detail, that was Planning Commission, or excuse me, Board of Commissioners authority, which is delegated to the Planning Commission to administer. County Engineer's Office and Soil and Water Conservation District in some instances, but mostly the county engineer serves in an advisory capacity. The county engineer or prosecutor provides legal guidance if there's a legal issue. There's no role at the township level in regards to floodplain management. Subdivision regulations is again Planning Commission authority with advisory from the capacity from the county engineer. Legal counsel is provided by the county prosecutor. We can require proof of compliance from the county health department. Township level, we can require proof of compliance with township zoning. The other aspect that we're involved, or the township may be involved with, if there's a rezoning that's required to allow for that development to occur, then that part of the process would have to be done before it came to this body. So in other words, the rezoning would have to be considered and in place before any application can be approved. Same for a zoning commission. They're involved with, there's a rezoning process. The zoning board of appeals may be involved if there's a zoning requirement that needs a variance from the township level, then they would be involved. Once they approve that variance, then that would show that's in compliance with the township zoning on meeting any conditions of that variance, or if it's just outright granted. And then of course the zoning inspector is involved in showing that it complies with the township zoning. Public improvements we already talked about. Erosion and sediment control. There is no role at the township level with sediment and erosion control. Access management, again, there's no role at the township level. So those three are strictly at the county level. Access management authority, again, is with county commissioners for county and township roads. State roads, that authority lies with the board of, or excuse me, the Ohio Department of Transportation. It's delegated to us to administer. And then county engineer's office helps us in an advisory capacity to help review like site distance and make recommendations. And again, the county prosecutor's office serves in a legal capacity. So with that, unless you have any questions of me, I'm going to turn it back over to Don.
And while Don's getting up, I'm going to just point out that these spots that you're looking at, the roles, these charts are very important ones for you to remember, because this is where the spaghetti noodles start to mix and we forget who's got what authority. And sometimes we have the thought, well, we really do like this and want that to happen, and we have to go back to, do we have the role, do we have that authority to do that? And in the absence of others doing, sometimes we step in or want to step in, and it's not, we don't have the statute that gives us that authority, nor is there the case law, or in the absence of either of those, is there an attorney general opinion saying that we can. So, Don, I'm going to turn it to you because I know you're biting at the bit to get going.
And I was going to point that out. I think, you know, in talking with Brad and Chris and Jerry, I think one of the problems, there appear to be some confusion on what you can do, what you can't do, that sort of thing. And one of the problems is, unlike most counties or most subdivision regulations, the regulations that you have, if I downloaded your book, has got everything in there. And if I gave you that book, it would have not only the subdivision regs, it would have your erosion sedimentation control regs, it would have your floodplain regs, everything. And it gives you this false sense of thinking, this is part of my job. And it really isn't. Chris upstairs told me that they're in the process of taking those out and separating those. I think that's going to go a long way to avoiding any future confusion. Because, like I said, they're absolutely right. The county commissioners in most of these instances are really the ones in control. That they control the public improvements on what the specs are going to be, you know, that sort of thing, whether or not a surety can be required. They've elected not to. So you have no authority to say, well, we want to let them post a bond. It's not your call, it's theirs. Erosion sedimentation control, that's their authority. Floodplain, their authority. Access management, except for a home rule township, and there aren't any in Licking County, that's their authority. So your role and like I said, it'd be helpful when these extra regulations are taken out, but your role is really gonna be 3 places in the subdivision regs when you think about it. And I know I'm simplifying this probably more than I should. But as I see it, 3 things. Number 1, you're gonna be responsible for review and approval of preliminary plans. Now, I suspect though, you are gonna rely on staff and the staff report the recommendation. If staff would recommend conditional approval, you're gonna incorporate those conditions within your decision, I'm assuming, I would. Second thing you're gonna be responsible for, review, approval of final plans. Same thing. You're gonna rely on staff, they're gonna make a recommendation, you know, that sort of thing. The third thing you get into, I don't know if you get into it a lot or a little or maybe none, but modifications or variances, for lack of a better term. The statute for subdivision regs basically allows for the subdivision regulations to provide for a modification or a variant. Actually, the statute says the rules may provide for their modification, the rules being the subdivision regulations, may provide for their modification by the commission in specific cases where, quote, unusual topographical and other exceptional conditions, close quote, require modification. So that's the authority. Your focus is on topographical and other exceptional conditions. My suspicion is, and I didn't look, I probably should have before I came. I didn't look at your variance procedure in your regs. But my suspicion is your variance procedure in the regs outlines the type of considerations you're required to make before you approve that sort of modification. But that's a third role. Now, when you're in that role, what, have you had a variance hearing?
Yes.
Okay. When you're in that role, you're acting in a quasi-judicial capacity. Make sure you swear people in. I'm assuming you do.
We don't swear at people, we swear.
Swear, yeah, swear. There's some you would like to. Swear them in. Take testimony and make a decision based upon the evidence presented at that hearing. Not what somebody may have said outside the hearing, not extraneous information. You're not allowed. Because once that decision's made, that individual, that applicant, has the ability to appeal that decision under what they call Chapter 2506. It's an administrative appeal to common pleas court. And what you want to do is make sure you've conducted a hearing where they can't ask to add additional evidence. If you've conducted a good hearing, and it meets the, you know, witnesses were sworn in, you have explained the reasons for your decision on the record, then a court won't typically open it up. But if you've not sworn witnesses in, if your decision is I move to approve, or I move to disapprove, that's it. There's no rationale in there. A court may very well say, we're going to let him supplement the record, and he gets a second bite at the apple. And you don't want that. I don't know, it's unusual to see an appeal of a planning commission variance hearing. But in my mind, this is the practical side of me, as opposed to the legal side. In my mind, those are the 3 areas that you are going to find yourselves. That's your role. You know, everybody's wondering, what's our role? That's your role. Those 3 areas: preliminary approval, final approval for a plat, and modifications/variances of the subdivision regs. Beyond that, everything else is typically commissioner-driven or staff-driven. That's the way the system works. Kick in if yeah, Chris.
I just have a question actually with some of the stuff that we've been working on. The public improvements, I don't know if you have any experience with this, but the public improvements have been kind of grappling with the concept of what it can actually require. So I know it's tied, specifically talked about being tied to the improvements that are shown on the plans that are required by 71110C.
Right.
So can the public improvement section, the 711-101, can it actually have rules that require improvements? Or can it only deal with improvements that are shown on plans required by the subdivision regulations and improvements required by the subdivision regulations?
I'm not sure I understand.
Again, so for instance, let's take sidewalks for instance.
Okay.
A practical example. If there's no requirement in the subdivision regulations to put sidewalks in, because I'm not sure if we have authority to do that or not, and kind of thing. So there's nothing stating that sidewalks have to be a part of this this development or this subdivision. Can the public improvement regulations require sidewalks? Or can they only say, if there are sidewalks, this is how they have to be constructed?
No one's ever asked me that. My gut feeling is the public improvement section doesn't go that next step that you're thinking. It establishes standards, it establishes how they're to be done, that sort of thing. But in terms of mandating that a particular improvement take place, I'm not sure they can go that far. Not the public improvement. Well, no one's ever asked me that.
That's a good answer, Doc.
No, that's,
I've been struggling with that for a while, so.
I would guess probably not. That's my guess. Just the way the statute is set out. Because it talks about rules, it talks about standards and specifications for the construction of. Da-da-da-da-da-da-da. It doesn't talk about the need for or the location of, it doesn't seem to go that far. And you can make the installation a condition precedent to the sale of any lots or lease or the issuance of building permit. If I had to guess, I would guess no. But it wouldn't be the first time I've told somebody, there's no case law I'm aware of on it. If you want to push the envelope, I'll defend you to your last dime.
So that kind of example, sidewalks is a pretty typical requirement.
It is.
Other things with streets and that kind of thing. So do you think typically those counties put those under the sort of arrangement of streets category, under subdivision authority? Is that typically where you think you would find
Yeah,
that as far as that's
probably.
So
That'd be my thought.
Okay.
Because when you're looking at that authority, to secure for proper arrangement of streets or other highways in relation to open space, traffic, utilities, access, recreation, light, air,
Recreation.
Yeah, you can justify a lot of that. I've never seen somebody go as far as bike paths. That I've never seen. But when you look at the purpose of the subregs, it's pretty broad. I mean, it's probably broader than it should be because it arguably even gets into density. And I don't think a subdivision authority should even go there. But it talks about for the avoidance of congestion of population. Convenient open spaces. What happens if this has open space? What happens if a township has a planned unit development regulation that requires a 30% open space set aside and says that it is to be used for passive purposes only, it's a no-build zone. And you add to your subdivision regs a requirement of a certain percentage of open space. What if they conflict? I mean, that's the problem with, I give a seminar on this once. I call it who's on first. And the problem is municipalities have a big advantage over counties and townships. In a municipality, it's one-stop shopping. I have one authority that regulates both the zoning and the plating. I don't have to worry about that. Not so in the unincorporated area. I have one body that is regulating subdivision rates, I have another body that's regulating zoning. And sometimes they conflict. The statute doesn't give you a good answer on how to fix it. What I've advised people is the only way to fix it is through communication. That's the only way. You communicate. I've seen townships in their PUD regulations, especially in Delaware, southern Delaware County. They're real big on this. They've actually established access points as part of their PUD zone. I think they have that authority. But what happens when they conflict with your community? It's not good. I ran into that situation one time. It's not good. And the problem is, you know, the poor developer, I hate to say poor developer, the guy's sitting in the middle. I remember one guy, you know, this guy said, I'll do whatever you say, just tell me what you want me to do. And you can't do both. But it's communication. I think people are a lot better. You know, years ago, Licking County had a reputation. There was things that were not all communication going on. And that's all it takes. But I think I think, Chris, back to your question, I'm not sure, I think I would rather fit it under sub-regs than I would under the public improvement. Or if I were really trying to cover my tail, what I would do is both. I would have them mimic each other. Because the commissioners have to approve both anyway. Why not have them in both places? And that way, even if they're pushing their authority under 711.101, I have the same requirement in 711.10. That's what I'd probably do. I've never had the opportunity or chance to do that yet, but that's what I would think about doing.
We have time for about 5 more minutes of question and answer before we take a break, or 7 minutes by that clock. So are there other questions?
What about the public improvement? Would it include things like road connections or road extensions that are not currently in existence? It's not related to a subdivision. It's just county or township roads per se.
Well, what you probably have is, it's a progression. The first thing you have, in order to do subdivision regulations at a county level like this, you have to have a thoroughfare plan. That gives you the basis of doing this. So when you're talking about road, and I'm assuming you do, but when you're talking about road connections, first thing I'm gonna look at was thoroughfare plan say. It calls for this road to go from here to here. Now this property here in the middle is not being developed. So I can't require them to make a connection when they're not being developed. But what I'm gonna do is when that farmer has a contract to sell to the developer, that's when I'm gonna make that connection. But the connections I would suspect are shown on your thoroughfare plan. And Jerry, you can.
Yeah, and what I'll answer, we'll just tag the team first.
Oh, good.
Okay. Yeah, what we have in this county is we have 2 things in place. As our MPO LCATs, we have a transportation plan, a thoroughfare plan that identifies an overall view and what road connections need to occur, where the improvements need to occur at intersections and roads. But then also, prior to some other things that have been cleaned up in our regulations, we also had in our regulations where we called our regulations the plan. It's not the right way to be doing it. We've seen how there's actually, you may want to talk about the court case where someone's comprehensive zoning ordinance is now considered a comprehensive plan. We've done that a little bit in our own regulations where we've allowed our access management regulations to also serve as a thoroughfare plan by the classification system we put in place. But in reality, the thoroughfare plan that we have is the one that's established by LCATs for all of the county where we look at the road network.
Yeah, I think you can get away with that, but there has to be something you can point to do this. But that's where you find it. Is that helpful?
Sort of.
I mean, when you're getting an application for a preliminary plan, or when you're getting a final plan application, is my suspicion right that 95% of the time, you're looking to staff for their recommendation? I mean, that makes sense. And that's what I would do. What I would be aware, and it's, I think, it goes back to what Jerry said. What you want to be aware of is your role. That's the key. It's your role. And your role is going to be in 3 places. Yeah, Chris.
I was just going to comment on that. Today's question, because I think it's something that, at least for me, was an unknown quantity about the public improvements section. We often call them public improvements. I think that's probably the most common name, but I think it's a little misleading because they are directly tied to subdivisions. And that's why I think a lot of times, at least I know I did, when I thought of public improvements, I thought they could apply outside of the subdivision plat. They could apply it to other things. They're the standards for every single improvement that's ever made. The county commissioners want to connect a road, or the township wants to connect a road. But it's only if and when there's a subdivision plat involved, which is going to be most of the time you have a platted roadway. But that's when they apply, I think is the answer. Is anytime where you're going to see that plat here, because it has to be approved by us, that's when the public improvement, as we're calling them now, subdivision improvement regulations.
That's what will happen.
Yeah.
Yeah. The problem sometimes I haven't seen this for a while, but I did see it one time a few years back, is you have a thoroughfare plan that's going to call for a road to connect. What happens then? What do you do in the situation where somebody finagles lot splits where they don't have to plat and they block your connection? I ran into that up in Delaware County about 10 years ago. And to be honest, there was nothing we could do.
Well, I don't want to take up a lot of time.
Oh, no.
But this is relative to the agreement that the county has with Southwest Lincoln Water and Sewer to provide water and sewer service to the interchanges on 161-37 at some point in time. Okay? So that, in my mind, is a public improvement, but it's not part of the subdivision. And so, who is involved with those kind of issues? The extension of capability from a political entity, a water and sewer district, outside of their original parameters into townships that were not part of their becoming to be, so to speak.
Their territory.
Right. So, I mean, because sooner or later, it's going to be a big problem.
That could be a discussion by and of itself.
Right.
I mean, in Franklin County about 10 years ago, there was a big fight over, you heard Brad mention a 208 plan.
Well, we've had that big fight here too.
A 208 plan is a fascinating political tool. And the city of Columbus, I give them a lot of credit. They did a great job in terms of using the 208 plan to allocate service territories in Columbus and preserve their growth areas. That's what they did. The 208 plan said, you go here, you go here. Jefferson Township, your next door neighbor over here, their sewer district. So I don't know that this county has a 208 plan. I don't know.
Oh, yeah.
Yeah.
Okay. So that 208 plan may very well have allocated where these entities go and who has.
It laid the turf, it didn't lay the lines. So that becomes part of the issue. So we have the watershed, we have those drainage areas, but it doesn't identify exactly the corridors or where they're going to be putting in the utilities to these areas to be serviced.
The problem you're going to run into, and you probably may be running into it now, is if I own property there that says it's going to be serviced by Southwest Licking, the lines aren't there. That's what the 208 plan says. You're in a difficult position because you're being asked to approve a plat that can't be serviced right now. And that's a tough spot. What would I do? I would probably do a bunch of research, and I may consider getting a formal legal opinion on what my authority is in those instances. Because the statute, when you're doing planning, allows you to require proof of, and I'm sure you're doing that, but, and I'm assuming that 208 plan is locked in the service area, unless it has an opt-out feature. I don't know if it does or not, I've never looked at it.
Well, with that, we've come to the end of the time that we had laid out for this work session. Again, we're going to edit this and have it available online so that you can listen to it again, see it, and we'll make sure before the meeting's over that those of you who didn't receive that handout that I was referring to as the most important, which apparently none of you have, you'll have it. So, Don.
Thank you for having me.
Thank you. They're going to be here for a few more minutes.
Oh, yeah.
Please,
You got any questions?
please
No
stand
questions
thanks
about
to
208 plans.